May it please your lordship. Lordship, this is a 439 bail application, second time lordship, 54 days in jail custody lordship. FIR on page 16 lordship. I am for Abdul Hai lordship. Abdul Hai only lordship. And recovered from lordship itself from Abu Hanifa.
Earlier rejection order.
That is lordship will find on page 22 lordship. Yes, lordship.
And Abdul.
Hai lordship. Lordship already perused lordship considering the length of detention.
Abyssal offender earlier also arrested in one Romania PS case, my lord. Let us, my lord, read this. Updated case diary may be called for, my lord. I will get it. No, my lord, 90 days.
It's a 90 days
90
because 89 C and A is C
90
is
days.
below.
Can you have it?
My lord, I'm not looking for on, my lord. I will try to get it on 21st of May, my lord.
Lordship, then today 54 lordship, another 10
68
days,
days, my lord.
68 days.
68 days.
Early.
16th of May.
Lordship, 16 I'll be out of station. 20 lordship can.
Yes.
The second bail application, Sachin, earlier rejected by your
FIR.
FIR lordship will find at page 8 lordship,
Or BA.
AB lordship.
Okay.
21/5, man. Attempt number 4, my lord, scan copy not yet received, my lord. Oh,
Actually, my senior is coming. My
Tell us, Mr.
Your Lordship, the petitioner is behind bar for 100.
Why this matter is listed before this?
One of the two accused were granted bail by your.
Where is that?
That order, Your Lordship, I could not annex. I came to know subsequent. That on the other day, I had the second.
Fire Dev Barman.
Yes. He is in custody for 1022 days. That is 2 years, 9 months, 11 days as on today. And out of 9 witnesses, 2 witnesses are examined.
Out of
9 witnesses.
total 9.
Total 9.
How many examined?
2. He is in custody since 22/7/2021.
Who are the others that we have given? Fire Dev Barman.
Fire Dev.
What ground?
Dev Brahma. They were granted bail because of the delay as well as nothing was recovered from their.
What is your case?
My case is that, Lordship, in the prosecution side said that, Lordship, in the truck I was alone, but that is not the correct position, Lordship. Actually, there are other persons also in the truck.
Who are you?
I am the driver of the truck, Lordship.
A huge quantity.
So
That
the
is difficult, Mr.
Lordship may consider the delay part, Lordship.
Delay part is there.
Only the 2 years, 9 months, 17 days,
You
Lordship.
have to make a balance in certain cases. Yes, go.
If,
Well, what do you say?
if, government has been seized from its conscious position. Recently, Supreme Court in case of Gurwant Singh said that in case of heinous crime, delay of trial is not a ground for granting bail.
That will depend in different cases. What we want is why there is delay in trial. That is what we want to know.
If I can assist from lower court records, Lordship.
What is the reason of delay? And you have instruction, who are the witnesses to be examined?
Lordship.
Have you gone through it?
No, Lordship.
To go through it, we are taking this matter day after tomorrow,
Can it be on Monday, Lordship?
Monday, next Monday. Okay.
I'll assist you.
You also can go through it. No problem. These are scan copies.
Lordship.
Liquid, one is.
NCB.
NCB. Scan copies of the record. That is allowed, list this matter.
Much.
Who are the witnesses and whom
Lordship.
Yes, I am entering appearance today, my lord.
Okay.
Record may be called for, my lord.
scan copies or
Yes,
what?
can be, my lord, only one, my friend has made a mistake, my lord. The post title, my lord, the case number is not mentioned, my lord. It will be, my lord, special
Why
and
this was earlier rejected
earlier rejected, my
by this court.
by this. Special NDPS case number 47 of 2022 of additional session judge Karimganj.
There was some mistake. Okay, call for the scan copies. Any other bail pending in this regard? No, no, not by this accused, co-accused.
They had
Is-
two accusers.
Who is Liton Mia? Where is the affair?
FIR, your lordship will find at page 10, my lord. 10, 10. Yes, my lord, there are 3 persons, my lord.
That was
Lordship will find at page 21. Name and address of the arrested accused.
Liton Mia. Rubel Ahmed Borbuya.
Well, Amina, we are appearing on Sajan Ahmed and Rubel Ahmed.
Hasan Ahmed earlier was disposed of not by this court, some other courts. Is that it?
No, my lord, page 51, my lord.
Yes.
50, my lord. 50, my lord. Order of your lordship, my lord.
No, this is 50 is a correction.
Correction, my lord.
And if you come to page 47, this was a case where application was filed for expeditious trial.
Yes,
This was not a bail.
47, my lord, lordship may say. Is 47,
Bail application, okay.
BA number 2205.
Now, this is 5.
Yes, my lord.
There's another bail application 3351 of 2023. You made any statement? Azan Ahmed Barbuya, is not it?
Lordship, that was also rejected by the Honorable Justice.
Where is your statement? Order dated 19/9, 466, is not it? And what about 4336 earlier?
My lord, in my petition is nothing mentioned, my lord, to be honest.
I will just record it, Mr. Doctor.
My lord.
Bail application number 466, this is pending. This is the present application.
Yes,
Now, bail application number 3351/2023.
3351
2023 disposed of on 19/9/2023.
my lord.
Another bail application is on 4336/2023.
43
4336
623.
23.
Hello.
Was disposed of on 28/11/2023.
My lord. And another
And
one
the
is
co-accused bail application 4348/2023, that Liton Mia.
43
4348/2020.
4338, my lord.
4348.
23.
23. You can have what happened, why not
I-
happened.
I-
On the prayer of Mr. L.R. Mujumdar, Learned Counsel. The lawyer can charge it.
My lord. Now it's very easy also.
All these cases are, most all of them are rejected.
My lord.
We are asked to submit a written to
Hearing concluded, judgment reserved.
oblige matter.
May I place one document?
Scan copy. Session.
So one judgment I have placed and
Ten copies were called for the case. Case there is there with Mr. But.
Actually, Asil, what-
Please give the case there. Yes, what you want to say?
what's it? The circle officer, Titapur Revenue Circle,
Hmm.
he sought for a verification report on the marriage certificate from the Register Muslim Marriage and Divorce, my lord. That report, my lord, was submitted by my lord Sir Kazi, my lord, second page, lordship, we find to the circle officer. First one is the letter issued from the circle officer.
Those are already available in the case there. CD.
oblige me.
Yeah, but- I can ask her to leave.
Yes, yes. But as far as the factual aspect is concerned, now it is all known. Have come against the order framing charge. Our basic case is, my lord, section 17A. Mandates a requirement which has not been followed. The lordships would kindly come to section 17A. এখন দেব না, Prevention of Corruption Act. I think lordship is holding a new book. Otherwise, the 17A was inserted in,
This is
2018.
17A.
yes. No police officer shall conduct any inquiry or investigation into any alleged offence to have been committed by a public servant under this act, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in charge of his official function or duty without previous approval, in case of a person who is or was employed at the time when the offence was just to have been committed in connection with the affairs of the union of. In case of a person who is or was employed at the time when the offence was alleged to have been committed in connection with the affairs of the state of that government, in case of any other person of the authority competent to remove him from his office, or at any time when the offence was alleged to have been, provided that no such approval shall be necessary for cases involving arrest of a person on the spot on the charge of accepting or attempting to accept any undue advantage for himself or for any other person. Provided further that the concerned authority shall convey his decision under this section within a period of 3 months, which may, for reasons to be recorded in writing by such authority, be extended by a further period of 1. So, my lord, if an officer is employed in the charge of a function which is connected with the affairs of the union, then, my lord, with the previous approval of that government, that is central, in case he is at the time when the offence was alleged to have been committed, does something in connection with the affairs of the state of that government. In any other case, the authority competent to remove him from his office at the time when the offence was alleged to have been committed. The only exception which has been carved out is, my lord, the trap cases. Otherwise, my lord, there is no exception as far as section 17A is concerned. Now, my lord, we often confuse with 17A, 197, 19. Now, Supreme Court has said, my lord, section 17A operates in different field, 197 operates in different field. Therefore,
17A
time
pre-enquiry.
exactly
19 is
before
cognizance.
cognizance,
Before cognizance.
and 19 and 197 are in perimeter.
Perimeter.
Now, my lord, we have made one compilation. I may hand over this, my lord. We have given our written argument, we have given the judgments, and most importantly, my lord, when the bill was moved before the parliament, my lord.
Object.
Yes, that's very important in this case. My lordship should kindly come to page 288. Please come to, my lord, 15.1. Clauses 12 and 14, 15.1, my lord. The official amendment intends to insert a new section
15.8.
17,
Paragraph
15.1.
15.1.
Towards the end, my lord. Towards the bottom of the page.
Okay. The official amendment.
The official amendment intends to insert a new section 17A to make it obligatory on the police
probe agency to obtain sanction of Lokpal in cases involving employees of the union or of the end of respective lokayuktas in cases involving employees of state before initiating any inquiry investigation against the public servant in all cases of corruption, and they mark the words, my lord, except where public interest, public servant is called red-handed. Any complaint to police probe agency shall be treated as deemed to be a complaint to Lokpal or Lokayukta as the case may be. However, sanction of prosecution would remain with the competent authority, and that authority shall have to convey its sanction within a period of 3 months, which can be extended by another period of 1 month, where a consultation with Attorney General, Advocate General is required. I have placed before this, my lord, the statement and objects is to highlight the fact that the intention of the legislature is to include all offences. Only exception was, my lord, when a public servant is caught red-handed doing something, whatever it is. So the case in hand does not relate to that exception. This is one of the limb of the argument, my lord.
Recommendation of the committee while placing for the amendment.
In other words, my
Amendment-
lord, we can say this is the Constituent Assembly debate.
Yes. Anything been dealt with in this recommendations as regards what should be hence relatable to any recommendation made or
Yes,
decision?
that is there. Those judgments are there. In other words, my lord, it must be relatable to due discharge of his duties. Assuming I have amassed wealth disproportionate
Understand?
to my known source
So
of income,
it must,
then it must
known
be in
source
discharge of
means-
their duty.
known source means my income from my service.
Yes. And my
Beyond
lord,
that, yes.
if I am not a DIG, nobody will come and pay me if at all the allegation is correct. Only when I am DIG, when I am yielding this baton, my lord, then only people will come to me.
Because why I'm asking this question,
Yes.
because they will rely on that Madras judgment where that,
Madras, I will show, my lord, is neither here nor there.
therefore, in that case, that whether it's relatable or not relatable, that is been.
Actually, my lord, Madras case has not taken note of anything. It only says in corruption cases or in cases under PC Act, this is not required. On the contrary, it is PC Act, my lord, which emphasizes on the requirement. Yes. Now, my lord will kindly come to, first, my lord will kindly come to, there's two more aspects factual before I take your lordships to the legal principles. Your lordship will kindly come to the petition, my lord. Page 185.
On 85 of your.
Yes. This is a standard operating procedure for processing of cases under section 17A. Now, lordship will kindly come to page number 190. Ranks of police officer for seeking previous approval under section 17A in respect of different categories of public servants. Please come to 3, my lord. Yes. Inspector General of Police or equivalent, public servant drawing at level so-and-so as recommended by the so-and-so is equivalent. So in our case, my lord, the sanction previous approval under section 17A ought to have been sought for by an officer of the rank of IG, whereas in our case, it was done by an additional DSP. DSP. Now, my lord, they knew there is a requirement. They sought permission from the state government. Question is, I am an IPS officer. Therefore, the appropriate government is the central government. Now, assuming there is some doubt, my lord, because I am an state cadre officer, subsequently promoted to
Promoted to
IPS.
Okay.
Then, my lord, at least the test would be who can remove me from service. As an IPS officer, I can be removed from office by, my lord, the Home Ministry. That's the appointing authority. And supposing, my lord, if sanction is also required under 197, it has to be by the central government. So therefore, there is no escape from the fact that Section 17A envisages a situation where before you proceed with even to investigate a case, yes, to the extent of registration of the case is okay, but beyond that, you can't do anything. The moment you find that Section 17A is there, then you have to take a previous approval. So these are the factual aspects. Now let us go to the legal principles, my lord.
The actual aspect is admittedly there was no sanction from that authority. you are-
Competent authority.
Competent authority.
And
So
the
your whole case is that in absence of the sanction, it will.
they cannot proceed. Therefore, question
Now,
of filing charge
what,
sheet,
uh,
question of, my lord, framing
I
charge.
want to say that moment the defect in not taking sanction for proceeding with the inquiry,
Was noticed by the trial court.
everything will fall.
Come to us, yes. Everything will fall flat. Yes. Now, first, my lord will kindly come to that compilation, page number 73. This is the judgment of Yashwant Sinha. Even if, my lord, in Chandrababu Naidu's case, there is a, dissenting opinion by Honorable Justice Bela Trivedi, and for which now matter is before in a reference before the Honorable CJI. No, this judgment was very much there. So therefore, to ignore this, how Madras High Court has ignored this, how our, my lord, trial court has ignored this. Yes. Page 73, para
It
117.
starts from which page?
Yeah, my lord, it starts from page 17.
10, no?
No, 29.
The judgment.
Yes, it
It's a long
starts from
judgment.
29. And I'll have your lordship's kind attention to page number 73.
Now, which will be the paragraph you will rely on here? Just
117.
117.
One paragraph. My lord,
That is a
now
page-
my duty is to place the law. What is the legal position with regard to it? In terms of Section 17A, no police officer is permitted to conduct any inquiry or conduct investigation into any offense done by public servant where offense alleged is relatable to any recommendation made or decision taken by the public servant in discharge of his function without previous approval, inter alia of the authority competent to remove public servant from his, kindly mark that word, my lord, competent to remove the public servant from his office at the time when the offense was alleged to have been committed. In respect of the public servant which is involved in this case, it is clause C which is applicable. Unless therefore there is previous approval, there could neither be inquiry or investigation. It is in this context, now in the facts of the case. So, my lord, the ratio decidendi of the judgment is Section 17A clearly mandates a requirement of seeking previous approval before even starting investigation. And unless that previous approval is there, the police is not competent to proceed with the case. So, my lord, our submission would be, even without, my lord, Chandrababu Naidu, this judgment was already there. The next judgment, my lord, will kindly come to Chandrababu Naidu's case. It starts at page 76. I'll draw your lordship's attention to, my lord, 2 paragraphs.
26.
No, first I will have your lordship's attention to para 30, that is Aniruddha Bose at page 93, 94. And as far as Bela Trivedi is concerned, Honorable Justice, my lord, it is para 66 at page 113. Now please come to page 93. One point which has been urged in relation to this authority is that this was not a contention raised by the parties in the judgment of the Yashwant Sinha and was not dealt with by the majority opinion. Hence, according to the respondents, a concurring opinion could not be a binding authority on a point that has not been dealt with by the majority of the Honorable Judge. The contention was this on view of Honorable Justice K.M. Joseph was a concurring view. But majority did not deal with this aspect. Therefore, the contention was this is not binding. On the contrary, Supreme Court says, since majority has not said anything against, therefore this concurring has to be treated as a part of the majority view. Mr. Rohtgi relied on the decision in the case of Ramesh Bhai so-and-so on this point. The ratio of this decision would not apply in the context of the judgment delivered. In case of Yashwant Sinha, as in the later authority, majority view does not reflect any discord over the concurring view. In my opinion, however, position of law laid down in the concurring judgment ought to be treated as a part of the main judgment, and that opinion would form a binding authority. So this is regarding my law, that my majority
Whether
view and concurring view.
that should be excluded
Yes.
from the, because since only one judge has
Ah.
gone to not others.
Others, yes. 2 o'clock, my lord.
2 o'clock, we have time, we'll conclude it.
Yes, yes, yes.
In the month,
Yes, Lordship. Till now, not yet listed, Lordship.
another time to make a mention.
You subject.
Much obliged.
Kindly come to page 94, my lord.
Is 94.
I should not, on top, I should not distinguish between the main judgment. Page 94.
Yes.
On top. I should not distinguish between the main judgment and the concurring view and isolate the reasoning contained in the concurring opinion and hold the reasoning contained in the main opinion to have the status of a binding proceeding. Concurring view is just as much a part of the main opinion and will be binding precedent composite with the majority view. Position of law would be different if the majority view had expressed either directly or by implication a con. This is not the case so far as judgment in the case of Yashwant Sinha is concerned. Hence, this principle of law contained in the concurring judgment would constitute precedent, even though it was expressed in a concurring judgment of a learned single judge, which the majority members of the bench have not deferred. Now, this is important. Thus, the steps taken against the appellant under 88 Act ought to be invalidated as the same did not commence with prior approval as laid down under section 17A of the Act. My lord, there are two propositions. One, and a concurring view also can be treated as a part of the main view. Secondly, my lord, when an action in violation of section 17A be bad in law. So this is one view of Justice Aniruddha Bose, my lord. Regarding the other view, please come to page 113. Para 66. The judgment in the case of Yashwant Sinha relied upon by Mr. Salve also would not be of any help to the appellant. Mr. Salve has relied upon the observation made by Honorable Justice Joseph in his concurring judgment, which according to Mr. Rohtgi was a discordant note in variance with the main judgment of the two judges. Be that as it may, what has been observed by Justice Joseph
In this part also, this court has not said that this is not binding. What it says is that for the given case, because their issue was what should be the time in that case to be
Whether
starting
whether
point of the
prospectively or
inquiry?
retrospectively.
Retrospectively. So therefore it says that this part is not relevant so far relating to this judgment, but it is not said that this is
So in any
reference
case,
is
my
not
lord, just
reference is not so far relating to 17.
implication of section 17A.
Implications more particularly prospective or retrospective. That is the issue in
Yes.
this Chandrababu Naidu discussion.
So therefore, my humble submission would be, my lord, then if my lord, if we don't take note of Chandrababu Naidu's case, Yaswant's case is still there, which categorically lays down the law that section 17A, or you can even proceed with the. Here is a case, despite that, my lord, things proceeded to the stage of charge.
Now, it will be will it be an absolute proposition or there should be an except that bribing and other
That-
exception
now
will be
that-
there
that-
or there should be a prima facie view that this is the conditions relatable and something.
Oh.
Let us just you enlighten on that.
Exactly. In fact, my lord, I'm obliged to your lordships, my lord. In fact, to articulate my argument, my submission would be, in case of, be it a case of disproportionate asset, be it a case of acquiring assets not known to the known source of income, be it a case of misappropriation of fund, as far as a public servant is concerned, section 17A would apply. Now, the main section itself carves out an exception that the question of sanction or previous approval will not be required only in case of trap cases. And in fact, that is, there is our High Court one judgment is there, that is a case of trap. Now, my
Now-
lord, in some of the judgments, now, for example, that Kerala judgment, it relies upon 197. Now, as of, there are two other judgments, so I have brought all the judgments in this compilation, my lord. As on that, to the best of our ability, judgment which are in our favor, those are against us, all we have brought on this compilation. Let me place one by all, then I'll come to the.
Just keep in mind both sides I am
Yes,
saying.
yes, my.
What are the offenses under the PC Act? What kind of offenses are
Section
described
13
in
basically.
PC Act?
Yes,
Because this 17A uses a word relatable to any recommendation made
yes,
and decision taken by public servant.
yes.
So recommendation made and decision taken. Now, will it be a case that it will be applicable in all cases? Or there are certain offenses, therefore we'll have to understand what is the scheme of the act and what are the offenses.
In fact, lordship is very correct, my lord. In fact, those discharge of function which are relatable to these two expressions, that alone will get the protection. And therefore, now, my lord, in some of the 197 cases, we apply the test of active service.
Hmm.
Now, we say to take bribe, or supposing, my lord, a border security force personnel, he is guarding the border. Now, they have, for example, a custom officer. He receives an information that some, what do we call it? Smugglers have intruded. Now, they have also the information that they're hiding in Mr. X's house. In the name of my lord Charles, they cannot go and rape somebody.
Yes.
That will be not protected by active duty.
Not active duty.
But here, unlike those cases, here the legislature itself says, what is the expression? Provided, sorry, no police officer shall conduct any inquiry or investigation into offence alleged where alleged offence
Offence
is
is
relatable to any recommendation made or decision
It
taken
is
by
not
in
even
discharge.
it is not even relatable to his official duty.
Yes.
It says relatable to recommendation made
Made
or decision taken by the public servant.
in discharge of his official
Official
function or duties.
So
Then-
not his general of discharge,
No.
it is recommendation or decision taken.
Yes. Now, my lord, supposing, my lord, let us assume for the sake of argument that the
Why it is in my, because we will have to be clear. And
Correct.
I have not got any specific things.
No, we have
interpreted-
brought one
okay,
or two authority on
okay.
this point.
Okay.
Let me place it then.
Yes,
with my-
yes. So that's why I am raising
No,
this so
absolutely.
that it can, you can.
But that principle, that what can be, the protection will be only when you, discharge duties in your official capacity, that principle will not apply here. Because 197 and 17 is totally different.
Yes, yes, that is different. Yes,
Please come to, my lord, page 120.
it's 120.
In fact, it starts at page 118. It's a case of Madhya Pradesh High Court, my lord. Division bench, Yogesh Nair and another versus State of MP. Please come to page 120. Para 7, 8 and 9. Learned counsel for the prosecuting agency may be correct in his submission that lodging of an FIR in absence of approval is not expressly barred by Section 17A of the PC Act. However, what has been prohibited in conduction of investigation by police officer, and since lodging on an officer is the triggering point of investigation, it is obvious that even if an FIR is lodged, investigation cannot take place without approval of the competent authority. In the instant case, after registration of the impugned FIR, the investigation is being conducted, but no charge sheet has been filed yet, and it is not disputed by learned counsel for prosecution that no prior approval of the competent authority for initiating and conducting the investigation. Therefore, the investigation conducted pursuant to the impugned FIR stands vitiated on the anvil of Section 17A of the PC Act. The investigation conducted subsequent to the filing of the FIR stands vitiated and is set aside. Liberties, however, extended also. My humble submission is, my lord, in this case, though the intricacies of the law has not been gone into, but prima facie a view has been taken that even in case of offences under PC Act, no distinction has been made, my lord. Only distinction is trap cases. When red-handed you are caught. Other than that, the legislature has not carved out any exception. So when legislature has not done it, my lord, are you not to construe the provision strictly? Panel statutes are always to be construed very strictly, my lord. We cannot use any liberal expression. Then, my lord, will kindly come to page number 122. The case from Rajasthan High Court. This is, of course, by a single judge, my lord, before Justice Dinesh Mehta, Angshu Yadav. Now we will kindly come to paragraph, page 125. Case of demanding bribe, my lord. Para 22 at page 125, section 17A is quoted. Then my lords will kindly come to page 126. Para 23. A bare look at section 17A reveals that no police officer can conduct an inquiry or investigation into an offence punishable under the Act of 1988 unless a prior approval of the competent authority is obtained. The approval of the competent authority in terms of section 17A, the sine qua non, has been held by the Supreme Court in the celebrated case of Yashwant Sinha versus CP. So, my lord, Yashwant Sinha is relied upon. Then, my lords will kindly come to page 127, para 25. Indisputably, allegation of demanding illegal gratification relates to discharge of official duties of the petitioner and no prior approval of the competent authority. As such, the proceedings on the very attempt to arrest petitioner on the spot on charge of accepting bribe, which has failed, may or may not be legal, but proceeding thereafter, further investigation and lodging FIR against the petitioner without approval of the competent authority is void of initial. Kindly see here, my lord. Now, it's no part of the official duty to demand bribe. Normally, my lord, in 197 cases, that's the view Honorable Supreme Court has taken, different high courts have taken. Now, here, my lord, because demanding of bribe is something which is connected with the discharge of official duty.
Because
the
that
same-
this is
In the
specific.
same vein, my lord, amassing assets disproportionate to the known source of income is also relatable to the discharge of the duty. It is only in discharge of duty that one can take bribe. My lord, legislature is conscious of the fact that he is committing these already offences. Yet legislature has come up with a
17A purpose is that no genuine officer or unnecessarily a person is harassed.
basically, my lord. If I would have been on the, I would have said, all right, will apply mine and pass an order. No, my lord. No, when the state's taxation is not required, it's more dangerous. Anyway, well, I'm not meaning this case as a whole.
As a whole, as a whole.
Yes, yes. So therefore, my lord, this section, this judgment takes care of the situation, a situation where demanding of bribe itself also says it requires. So demanding bribe or amassing wealth disproportionate to known source of income, there cannot be any distinction in my humble submission. Then my lord will kindly come to that, my lord, famous case of Maharashtra, that recent case, that my lord, the
Deshmukh.
Home Minister's case.
Let's move.
Anil Basantrao Deshmukh. It starts at 129. Lord will kindly come to page 160. Para 82. In our understanding, the aforesaid extracted observation in the case of Yashwant Sinha cannot be read rehearse the context in which those observations were made. The aforesaid observations with respect do not lay down a proposition that even when a constitutional court is convinced about justifiability of a cause and necessity of a fair and investigation by an independent agency, Section 17A operates as a fetter on its power to order such investigation. On a proper construction, in our view, aforesaid observation underscored the restrictions to inquire an investigation qua the investigating agency and not against the court, which finds it expedient to exercise jurisdiction under Article 226. My lord, Anil Deshmukh's case, it was the court who directed. It was then an argument was advanced, that then also Section 7. For example, Lordship knows under DSP Act, Section 6, when court, that's constitution based judgment, when court directs, no consent is required. It is only when, the government, central government wants to take over a case, then consent is required.
That states consent.
Same principle has been applied here. So this is a division bench judgment of the Bombay High Court. So, my lord, the law is, if the court directs an inquiry having regard to the facts of a case, then that Section 17A would have no application. This is only a proposition for the limited purpose. Then, my lord, will kindly come to Shankara Bhatt versus State. Page 169. That Kerala High Court case. Now, this is interesting, my lord.
Here, page.
Shankara Bhatt
That I
versus-
have got, Sankara, then
Ah.
relevant page.
Yes, please come to page 175. Para 21. This seems to be in perimetry with Section 197 CRPC and also in tune with the scope of the law laid down by the Supreme Court in various decisions referred to earlier. While discussing the scope of Section 197(1) CRPC, if Section 17A is interpreted as intending to cover every investigation, inquiry, or inquiry into any offense allegedly committed by public servant, then it would have to run counter to the spirit of all the above decisions. A contra view that Section 17A covers every offense would have resulted in a dichotomy by which prosecution of a public officer for offense under IPC and PC Act may not require sanction under Section 197(1) CRPC, IPC for offences not relating to acts done in discharge of official duty or to be purported official duty. Whereas previous approval, which is more rigorous provision, would be required in relation to inquiry or investigation against every other officer done by him. Hence, an interpretation in tune with earlier entire decisions of the Supreme Court under 197(1) CRPC will have to be adopted, which will be in consonance with the object of Section 17A. Now, what Kerala High Court wanted to say, my lord, on the contrary, the Kerala High Court wanted to say the purpose of 197 and 17A is same. Therefore, why not we adopt the principle which Supreme Court has laid down in case of 197? That is, that it must be connected with the discharge of the duty. Now, my lord, please come to, for a moment, page 86. That my lord Chandrababu Naidu's case. Why this view is palpably wrong? Now, naturally, Lordship will go by the Supreme Court, not by a High Court judgment which is contrary to Supreme
Page
Court.
86.
Page 86. The scope of operation of Section 17A of the Act of 88 is, however, different from that of Section 197. The requirement of taking sanction under Section 19 of the Act also is at the same stage. Unlike Section 197, which is near identically phrased as same section in earlier version of the code, Section 17A of the Act imposes a restriction on police officer at inquiry stage itself from proceeding against a public servant in relation to any offence alleged to have been committed by him, relatable to any recommendation made or decision taken by such public servant without previous approval of the authorities stipulated at that section. We do not think the cases arising out of Section 197 of 73 Code would give proper guidance for interpreting the provisions of Section 17A of the Act, because in the cases under 197, the decision on requirement for sanction is taken at the stage of taking cognizance. Now, this is important.
That is what I am asking.
Huh?
There are different stages. This
Yes.
sanction are two stages.
Yes.
One is before inquiry and trial. And what is the object of incorporating 17A when already there is Section 19?
The idea is, the answer is here now. Can you see now? Thus, there is inbuilt scope of application of judicial mind to assess at least prima facie if an alleged act falls within discharge of official duty or not. That is under 197. Under provisions of Section 17A of the Act, there is no scope of judicial application of mind in determining if flaw in making recommendation or taking decision is interwoven with discharge of official duty or function or not. Moreover, the qualified embargo therein is on a police officer. On the point as to assessing whether offending act is in discharge of official duty or not, having regard to the nature of the duties of a police officer, he is less equipped to assess that factor which involves some form of judicial application of mind. No material has been placed before us to demonstrate that concerned police officer had undertaken any exercise for prima facie forming an opinion as to whether the offence alleged against the appellant was relatable to any recommendation made or decision taken by appellant in discharge of his official duty. So, my lord, this is the reason. Honorable Supreme Court, though, my lord, it's a dissenting opinion, was of the view that unlike in 197, at the stage of 197, there is already application of mind in some form of the judiciary. But in case of, my lord, 17A situation, there is absolutely no application of mind. So it was considered by the legislature, my lord, that the IO or the police officer, he may not have the expertise to find out whether it is in discharge of duty, whether as a result of recommendation or not. The idea why legislature has prescribed this. It is not the function of the court, my lord, in my humble submission, appeal over that. If the, my lord, legislative intent is visible, if it is, my lord, ostensible, if it is discernible, then it is the duty of the honorable court to give effect to that. So in my humble understanding, my lord, the Kerala High Court judgment and the Madras High Court judgment which state relies are of no, absolutely of no help. Now, Kerala High Court judgment relies on 197. On the contrary, Supreme Court says, sorry, it operates in two different fields, therefore it cannot. Then the Lords will kindly come to back to the judgment at page 177 now. Para 27. Para 27. Applying the above legal principles, I am of the firm opinion that in the cases and had which involve allegation of falsification of account, breach of trust, and misappropriation of fund or acts which are explicitly criminal, no prior approval under Section 17A of the Corruption Act is required. Hence, all criminal miscases are without any merit. So this is the view of the Kerala High Court. So my lord, now it's a judicial legislation saying that explicitly that falsification of accounts, breach of trust, misappropriation. My lord, Section 17A is a provision which is incorporated in PC Act. It is offences under the Act. The only exception is trap cases. Therefore, my lord, with utmost respect, I'll submit this Kerala High Court judgment. It cannot have any bearing. My lord, next at page 178 is our High Court judgment. Here, my lord, it's a case of trap. So maybe the learned single judge is correct. At least, my lord, I will not call upon your lordships, to take any help from this case, because it again referred to Shankar Bhatt and my lord, another case called Devendra Kumar versus CBI. Now here it's a case of my lord, paragraph 2. Please come to page 179, my lord.
179.
Yes, para 3. The factual background of filing of the present petition is briefly stated as under. On 15/9/23, Sankho Swargiri, Deputy Superintendent of Police, Directorate of Vigilance and Anti-Corruption, Assam, launched an FIR with OC ACB Police Station to that during investigation of ACB PS under Section 7A of the Prevention of Corruption, a trap was laid down at the chamber of Sri So-and-so, the then Chief Engineer, Guwahati Municipal Corporation, and he was arrested on a trap operation in connection with the said case for demanding and accepting illegal gratification. Well, both the components are there. Demand is also there, recovery is also there. So this case cannot be of any help. Take the, to the deciding our case, my lord. The case of acquiring disproportionate asset. So I would respectfully submit this is a case covered by the proviso. Then my lord will kindly come to this Devendra Kumar's case at 213. The best of our knowledge, my lord, these are Devendra Kumar. It starts at 193, and I'll have your lordship's kind attention to page 213.
Starts at 222.
Yeah, it starts at, my lord, 193. Para 36 at
Yes.
page 213. Please come to the last
Paragraph.
paragraph 36. Please come to the last three sentences, my lord, towards the bottom. The bar to inquiry or investigation under section. Yes. The bar to inquiry or investigation under Section 17A of the PC Act is appropriate. Such alleged offence as may be relatable to any recommendation made or decision taken by the public servant in the charge of his official function or duty. In the present case, there is no recommendation or decision on record by any public servant in the charge of his official function. It was only discharge of the official function that could become the subject matter of seeking approval of an employer, that is central government. The proviso to section 17A stipulates that provided that no such approval shall be necessary for cases involving arrest of a person on the spot on charge of accepting or attempting to accept any undue advantage for himself or for any other person. This proviso clearly refers to cases where the charge is of accepting or attempting to accept undue personal advantage or for any other person. The purpose of section 17A can be read to be only to provide protection to officers, public servants who discharge their official functions and or duties with diligence, fairly in an unbiased manner, and to the best of their ability and judgment, without any motive for their personal advantage or favor. A public servant cannot be possibly left to be under the constant apprehension that bona fide decision taken by him or her be open to inquiry or investigation on whimsical complaint of a stranger. Section 17A, as it reads, and the legislative intent in its enactment can only be to protect public servant in bona fide discharge of official function. However, when the act of a public servant is expressly criminal or constitutes an offense, prior approval of the government would not be necessary. This, in my humble submission, my lord, not be correct, my lord. Especially keeping in view the para 18 of my lord.
This is by
Justice-
Delhi High Court.
Just no, my lord. That
This judgment is
Aniruddha Bose is
This judgment is by Delhi High Court.
yes, my lord. I think it starts at
193.
193.
193. Devendra Kumar, Delhi High Court.
It is by Delhi High Court. I said, my lord, I'll place all the
No,
judgments.
that is
till then-
important for us.
Yes,
How the views are being taken by all
yes.
pan India. That
In
is,
fact, the view taken is something akin to 197. That due discharge of duties is no part of duty of a public servant to acquire wealth or to demand bribe. But despite that, my lord, section 17A has been, enacted. There is a purpose. Then my lord will kindly come to this judgment, I think which lordships was referring to. That state of Karnataka versus Subegaura.
this
Starts
is,
at
I
page
think, 19,
220.
so far relating to 19.
190.
This is so far relating to 1960.
90, madam. Perhaps it may not be of any assistance. I'll just refer to para 11 at page 226. The combined reading of subsection 3 and 4 of section 19 makes it clear that notwithstanding anything contained in the code, no finding, sentence, or order passed by the special judge shall be reversed or altered by a court in appeal, confirmation or revision on the ground of absence of or any error, omission, or irregularity in sanction required under subsection 1, unless in the opinion of the court, a failure of justice has in fact been occasioned there. Subsection 3 and 4 further postulates that in determining under subsection 3 whether the absence of an error, omission, or irregularity in sanction has occasioned or resulted in failure of justice, court shall have regard to the fact whether the objection could and should have been raised at an earlier stage in the proceeding. Basically, that even if there is some irregularity, that will not vitiate
That
the
is
fact.
just prescription under the
Because
section
only
9.
because Lordships have referred to this, as I have brought on record. Then my lord will kindly come to page number 231. This is basically, my lord, on construction of a panel statute, page 244. '27. towards the bottom. The penal statutes are required to be strictly construed. It is true that the penal law must be construed according to the legislative intent as expressed in the enactment. In chapter 1 of G.P. Singh so, the intention of the legislature thus simulates two aspects. In one aspect, this carries the concept of meaning, is what the words meant, and in another aspect, it conveys concept of purpose and object, or the reason and spirituality, pervading the thorough through this statute. Process of construction therefore combines both literal and purposive approach. In other words, the legislative intention, that is true or legal meaning of an enactment, is derived by considering the meaning of the words used in the enactment in the light of any discernible purpose or object which comprehends the mischief and its remedy to which enactment is directed. The words of so-and-so, construction of a statute, the words of an act are to be read in their entire context, in their grammatical and ordinary sense, harmoniously with the scheme of the act, object of the act, and the intention of the parliament. This formulation later received approval of the Supreme Court and was called the cardinal principle of construction in both constitutional and statutory interpretation. The court is supposed to exercise discretion in determining proper relationship between the subjective and objective purpose of law and help the law achieve its purpose. While giving effect to the legislature's intention, if two reasonable interpretations can be given, penal statute, the court would generally adopt the interpretation that avoids imposition of penal consequence. In other words, a more lenient interpretation of the two needs. In other words, one in favor of the accused needs to be adopted. So, my lord, these are the case laws. Now, having regard to these case laws, lordships will kindly come to the impugned order. It starts at 175. Please come to page 181.
Is
181. Peruse the decision relied on by learned counsel for the parties. The Honorable Supreme Court Yashan Sinha's case has discussed the importance of compliance of amended provision Section 17A of the PC Act to conduct an inquiry or investigation into any offence allegedly relatable to any recommendation or decision taken by the public servant in discharge of his public functions or duties. Facts of Himanshu Yadav's case are totally different than that of the facts of the case with hand. Case at hand relates to accumulation of disproportionate properties and the legal source of income of the accused. The Honorable Madras High Court in Dandapani's case has decided that previous approval in conducting an inquiry under Section 17A is necessary when the alleged offence has been committed, which is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions. But for the alleged acquiring assets of disproportionate to his known source of income during check period of a public servant, approval of Section 17A of PC Act is not necessary. The case at hand, allegation against the accused so-and-so is that keeping a public servant acquired properties which are disproportionate to his known source. So as per the decision of the Madras High Court, passed in so-and-so, prior approval is not necessary. On perusal of the materials on of materials on case record and diary, it appears that during investigation, the investigating agency was able to recover some incriminating document shows that the accused Sri Hazarika and his wife acquired huge properties, and list of the acquired properties clearly mentioned is annexed. The expenditure is annexed C of the charge sheet. So far as accused so-and-so is concerned, admittedly he is a friend of the accused. He used to transfer money to daughter of the accused through account of Afroz Ahmed. During the hearing on the charge, learned counsel for accused submitted that accused purchased a flat from Ronak Ali Hazarika. Pay price of the flat in installment and has been depositing it. Whether accused Farid Ali was in involvement in the conspiracy in accumulation of disproportionate Ronak Ali Hazarika, whether accused Farid was sending money to daughter through the bank account of others as claimed by prosecution, or he paid the price of the flat in installment, count of accused are matters of trial. A charge is a written notice of the size and specific accusation against the accused person, which they are required to meet. Presumption of commission of an offense on materials on the court is sufficient. It is not necessary to meticulously examine. But this was not even the subject matter. It was not a case where we are saying you can't frame charge on the facts of the case. Had it been a case,
Your only ground was for
non-compliance of section 7.
70.
So, my lord, page 182 is absolutely irrelevant. What I find very interesting from the trial court's approach is, my lord, the learned trial court preferred to ignore a Supreme Court judgment to prefer a Madras High Court single bench judgment. Something, my lord, it's shocking. Well, there is not a single line why Yasin Sinha's case is not applicable. So, my lord, this is the view of the trial court. Madras High Court has said that in case of acquiring disproportionate asset, I mean, section 17.
What is the Madras High Court judgment?
Yes, we have given, my lord, in that compilation.
It is here in the
Yes,
compulsion.
page 17.
Yes, 70.
17.
The Dandapan.
Page 25, para 12. In the case on hand, the petitioner has not been charged with any
Paragraph.
12, my lord, page 25. In the case on hand, the petitioner has not been charged with any offense relatable to any recommendation made or decision taken by him while discharging his official function or duties. But on the other hand, FIR came to be registered for allegedly acquiring assets disproportionate to his own source of income during the check period between so and so. Considering the above, I am of the view that prior approval under section 70 is not at all necessary, that the said provision is not applicable to disproportionate asset case. What is the basis of saying so, my lord? Discernible from reading of section 17A. Section 17A once, my lord.
This is what I am asking. What is the offense?
Yes. Kindly read, my lord. Kindly see. No police officer shall conduct any inquiry or investigation into any offense alleged to have been committed by public servant under, kindly mark this word, this act, where the alleged offense is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions or duties without previous appeal. So, in respect of any offense under the PC Act, and it is stated based on discharge of duty or on the basis of making some recommendation, alert, is it necessary to write that sentence? My lord, that means it has to be indicated that he acquired disproportionate asset based on recommendation made by him. Then it will be applicable. It's absurd, my lord. It is implied. That's why, my lord, that judgment which I have placed. Yes. If your lordship would kindly come to page 86 for a moment.
Compilation.
Yes. Sixth line from the bottom. Sentence starting with under the provisions of section 17A. The lordship got it, my lord.
At paragraph 18.
Yes.
Page 86.
Sixth line from the bottom. Under the provisions of
Yes, yes.
under the provisions of section 17A of the 88 Act, there is no scope of judicial application of mind in determining if the flaw in making recommendation or taking decision is interwoven with the discharge of official duty or function or not. Moreover, the qualified embargo therein is on a police officer. Kindly mark, moreover, the qualified embargo therein is on a police officer. On the point as to assessing whether offending act is in discharge of official duty or not. Having regard to the nature of duties of a police officer, he is less equipped to assess that factor, which involves some form of judicial application of mind. No material has been placed before us to demonstrate that concerned police officer had undertaken any exercise for prima facie forming his opinion as to whether offence alleged against the appellant was relatable to any recommendation made or decision taken by the appellant in discharge of his official duty. My humble understanding, subject to what your lordship may say, the Honorable Supreme Court took note of the fact that situation which evolves in a section 17A exercise and section 197 is totally different.
Because according to what you will argue is that at the stage of 197 or say per se section 19, there will be
Already
an
there is a judicial application
application of mind is
which is
mind.
not there here.
Because there is some mandate prescription who will have to do what manner application of mind, everything.
Precisely.
But in case of
17A.
starting an investigation, it is the police officer who will have to start on the basis of whatever material he has collected. So therefore, he will have to take
And
a
more particularly, a police officer is less equipped to know whether the allegations constitutes that, whether it is a part of the recommendation,
whether it is interwoven or not.
interwoven.
Therefore, according to you, that stage, therefore, legislature in its wisdom under section 19 even clarified that defect in sanction will not defeat the entire proceeding.
Yes.
Section 19. Now, whether that principle can be applied in section 17, according to it is no,
No.
because
It is not provided.
this is not provided. First, second is that it is a stage where only inquiry starts. So therefore, to protect an officer in discharge of his duties, what he have done is to inform his employer, see this material we have gathered or we want to proceed with him, please give us to investigate against him.
They can apply to the central government will give sanction, you proceed. And my lord, kindly see the manner in which the trial court has proceeded. Lordship feels that you can set aside this order and remand this order to the my lord trial court. Let them decide in accordance with law. Madras High Court is not the gospel's truth, my lord. Why Yashwant Sinha's case was ignored? Where there is a, my lord, it is unqualified. In fact, Yashwant Sinha is an unqualified judgment. Or please, Chandrababu Naidu, there is a dissenting view, Katre is referred. My lord, as far as Yashwant Sinha's case is concerned, my lord, why the, trial judge preferred Madras High Court over Supreme Court judgment? That is something, my lord, I could not understand.
Now
And that
tell us
principle,
why legislature has used this word recommendation made and decision. Why not that the in for in an inquiry under the provision of this act,
this is not required.
it will be required. Why this word is used?
These words are used because, my lord, the discharge of function must be connected with official function. Unlike in other cases where it is
So therefore,
presumed.
what are the offences under PC Act?
Yes, let us see, my lord.
Let us see what are
Yes.
the offences under, what kind of offences are
Yes.
there in PC Act.
First come to section 7. Any public servant who obtains or accepts or attempts to obtain from any person an undue advantage with the intention to perform or cause performance of public duty improperly or dishonestly, or to forbear or cause forbearance to performance such duty either by himself or by another public servant, or obtains or accepts or attempts to obtain an undue advantage from any person as a reward for his improper or dishonest performance of a public, or forbearing to perform such duty either by himself or by another public servant, performs or induces another public servant to perform improperly or dishonestly a public duty, or to forbear performance such duty in anticipation or in consequence of accepting an undue advantage from any person, shall be punishable with imprisonment for a term, shall not be less
What are
than
the
2
offences here? 13.
Yes,
Let us see straight away 13.
yes. A public servant is said to commit the offense of criminal misconduct if he dishonestly or fraudulently misappropriates or otherwise converts for his own use any property entrusted to him or any property under his control as a public servant, or allows any other person to so to do, or if he intentionally enriches himself illicitly during the period of his office. A person shall be presumed to have intentionally enriched himself illicitly if he or any person on his behalf is in possession of, or has at any time during the period of his office been in possession of pecuniary resources or property disproportionate to his known source of income, which the public servant cannot satisfy. So this is the offense. So to say by one line that this is excluded from the purview of 17A, in my humble submission, my lord, is absolutely wrong. And see, my lord, kindly see this explanation. A person shall be presumed to have intentionally enriched himself illicitly if he or any person on his behalf is in possession of, or has any time during the period of his office been in possession of pecuniary resources or property disproportionate to his known source of income, which the public servant cannot satisfactorily account for. Decidedly, this has to be in discharge of official duty. It can't be without nobody. If I'm not in office, why people will pay me bribe, assuming the allegation is correct?
Okay.
Therefore, my lord, I don't find, subject to what your lordships may say, my lord, I don't find any legitimate reason or justification to prefer, my lord, Madras High Court judgment for the, my lord, unqualified view of the Honorable Supreme Court, Prashant Sinha's case. So that being the case, my lord, either your lord, I think, my lord, the best way would be to either set aside this order and remand the matter back to the trial court to take a decision in accordance with law.
Yes, Mr. Fukun.
My lord. Here, my lord, before my lord, arguing the case, my lord, may I place the FIR first, your lordships? FIR page, your lordships?
Just a minute, just let. Yes. Page,
Page 21, your lordships.
the doctor. Not be possible today. Instead of keeping you waiting. Give a date, we'll see. The division
Can we
bench-
Jiten Sharma sir is, others can go.
No, I also think so. Instead of keeping all, I generally do it, knowing it. Unnecessary keeping others waiting. If, yes, Mr. Doctor is interested in arguments, that is a different issue. 13th. So our idea is to dictate the order in the court. That's why we fixed it. So we'll get on that day. This will not, even if he concludes, we will not make it CAV. We'll keep another day. Again, any query may come because it will have a bearing either way. So if any query comes, so that it is not surprise for you. So we may fix another.
Lordship,
Yes.
at page 21, your lordship, the FIR. An information was received at the office of the Superintendent of Police CM Special Vigilance Cells Assam regarding disproportionate assets assumed by Ronak Ali Hazarika, IPS Deputy Inspector General of Police Border Assam, and preliminary inquiry and thereafter the regular inquiry was initiated as per approval of the so-and-so dated 13/7/21. Accordingly, RE number 221 has been initiated and trust me for the inquiry. Upon due approval from the Chief Ministers of Assam to inquire into the complainant of disproportionate assets amassed by Ronak Ali Hazarika, IPS Deputy Inspector General of Police Border Organizations, Assam, I, along with the member of the seat, had collected the documents pertaining to the complaint petitions. During inquiry, it is found that Ronak Ali Hazarika possess immovable and movable assets to the tune of rupees 1,01,36,000 so and so during the period from 1992 to 2021. During inquiry, it is found that income of Ronak Ali Hazarika and his wife from all legal sources is found at tune of rupees 1,74,65,000 so and so. During inquiry, it is found that so and so incurred expenditure to the tune of rupees 3,61,18,400 so and so under different heads such as educational expenditures of his children's till date of rupees 1,74,12,947. After computations of his assets, income and expenditure, it is found that income of so and his wife from all legal sources is approximate to the tune of rupees 1,74,65,529 and expenditure is approx to a tune of rupees 3,61,18,451. This is likely saving income expenditures is approximately rupees minus so and so against his likely saving of rupees such and such amount. He possesses assets to the tune of rupees 1,01,36,401 approx. Thus, he possesses the disproportionate of assets to the tune of rupees 2,87,89,303 against his known source of income. Reportedly, the vehicle used by the Ronak Ali Hazarika bearing registration number so and so, Mercedes registered in the name of one Raman Kumar of Delhi at Mal Road, Delhi. It is strongly suspected that the suspect officer might have purchased the Mercedes vehicle from the Raman Kumar by a secret agreement and kept the vehicle at his disposal without changing the registration number. So-and-so stated that his wife was appointed as a financial advisor in a Max Life Insurance since 3-4 years back and getting commissions, incentive, etc. from the company, but he is unable to provide her total annual income. It may be mentioned here that His wife started her job 3-4 years back, but all the landed property were acquired and registered in her name while she had no source of income. Therefore, it implies that all the properties are acquired by so-and-so in the name of his wife. International travels history of so-and-so has been collected, and it's revealed that he had left the country and traveled abroad to most of the Islamic countries 9 times without permission from the competent authority, and therefore has been asked to submit the details of travel, stay expenses of his family members' foreign visits, but he has refused to cooperate during the inquiry period. Apart from the salary account, the State Bank of India's suspected officer and his family members' accounts of Axis Bank, Yes Bank, etc., and huge amount are found to be deposits in cash while he was posted in Bongaigaon during the period of 2019 to 2021. Total amount credited during the last 2 years of rupees so-and-so 3,07,33,587.95, out of which the total cash deposit is 59 crore 72 lakhs 59 lakh 72,150. During inquiry, it was found that the cash deposits were made to the account of the daughter of the suspect officer several times by one Afroz Ahmed. And during examinations of the Afroz Ahmed, he stated that he was given cash amount to 2 to 3 lakh each time by one Farid Ali, who happened to be the closest friend of the suspect officer. And as directed by Farid Ali, Afroz Ahmed would deposit the cash in the account of the daughter of Ronak Ali Hazarika. During inquiry, it was also found that the cash deposits were made to the account of the daughter of the suspected officer several times by one Kamal Sunwal. And during the examinations of Kamal Sunwal, it was known that the Ronak Ali Hazarika had given him rupees 10 lakh in check as a debt during the early pandemic periods, and therefore he were repaying back the money to the so-and-so by depositing the amount of cash in the account of the daughter of the so-and-so. The suspect officer was called for recording his statement on 22/9/21. Accordingly, he appeared but refused to cooperate with the inquiry. He was directed to submit the pro forma statement form number 1 to 6 on movable, immovable properties by office memo number so-and-so, dated so-and-so. But he has neither submitted the same nor he sought time for submissions of the pro forma statement. He had 5 passports in his name issued in different years by the passports authority, for which he was asked to furnish the passport from scrutiny of his foreign visit, but he refused to deposit the passports and stated that he will furnish the recent passport only. He appeared on 22/9/21 and submitted a letter for keeping the RE in abeyance and calling a scat order of the regular inquiry register of Director Vigilance Anti-Corruption Assam, who also implies that he was unwilling to cooperate. He also submitted a letter dated so-and-so stating that he wanted the copy of the complaint petitions and other material, and then only he will provide the information sought by us. Under such fact and circumstances, it implies that he will neither cooperate nor submitted the required documents relating to the inquiry. The above fact and the circumstances are sufficient evidence against the Ronak Ali Hazarika for intentionally enriching himself illicit during the period of his office, which is in contraventions to the Section 2C of the PC Act, and he being a public servant is in a possession of disproportionate asset, which is a criminal misconduct under Section 31B of the PC Act 2018. He owns assets that are out of sync with his legal source of income, where his net economic assets significantly exceeds the assets he should possess after accounting for his assets that he previously held and all legal source of income. He occupied a public office and his positions of disproportionate assets during the period of his office. He was unable to satisfactory account for how he could amass a pecuniary resource, cash deposits in his bank account from unknown sources, which is disproportionate to his known source of his income. The percentage of disproportionate assets found to be 164.80%. This is the Mailad FIR. And thereafter registering the case, and these sections has been Mailad implicated. And now, after that Mailad after detailed inquiry and the evidence they have collected by the IO, and file a charge sheet. The charge sheet at page 48. At page 48, Your Lordship. From the FIR prima facie, it's revealed as, my lord, it's a pure case of, my lord, disproportionate assets case, my lord. There is no such case, my lord, where he was taking bribe or, my lord, the misappropriation of the public funds. That is not there. It is a purely, it's from the prima facie, it's revealed from the FIR that during his office, my lord, during his, while he in service, my lord, he accumulated some disproportionate assets. Now,
Tell us,
my lord,
how this inquiry was started on the basis of page 24.
at page 24.
Correct.
Page 24, no? It's a regular inquiry. no? At
So
page,
kindly come to page 24. Some Hassan Hanasur Ahmed has lodged a complaint against Superintendent Chief Minister still. So the inquiry started with this.
Hmm.
Therefore, just
my lord,
thinking. So basic object of 17A is to prevent frivolous
my lord,
inquiry against officers.
my lord, my lord.
Now, decision in inquiry started on the basis of this inquiry.
Hmm.
Now, was it not necessary on receipt of this that we have received inquiry against your officer? Let us investigate or do an investigation. Because here the allegation is basically he is a very corrupt officer, acquired money through this, that. This is a general public.
My lord.
Just take note of this
Right.
aspect,
Hmm.
furthering your argument. Yes.
That's why, my lord, the regular inquiry was conducted later on.
Therefore, the word uses, no police officer shall conduct any inquiry or investigation.
This is the, my lord, object of the 17A.
17.
Yes. Now we say
So
that, my
therefore,
lord,
that is the,
Yes, this is
also
the
a
main-
query, the
yes.
originates with this complaint. Now 17N's object is basically to prevent this kind of,
Yes, yes.
not this kind of,
my lord,
genuine will
Genuinely.
definitely be
Right.
given permission by the authority. Okay, you proceed with it. So that a officer is genuine officer is protected.
yes,
This is the intention
the
of the
intention of the
legislation.
17A.
Now we'll come later on these two parts. One is whether it's a specific environment is required in an FIR or anywhere to have the sanction. Or if you say that you are a corrupt person, you have acquired what, so and so, that itself will amount an offenses, which in it definitely it can of your decision or something like that.
my lord.
These
Yes.
are the what Mr. Chaudhary
Yes,
has.
yes, my lord. That is the here main question is that, my lord, the defense counsel say that, my lord, the petitioner contention is that in my cases 17 is required because I am a public officer. But our state contention is that no, 17 is not applicable in your case because why I'm saying, my lord, simple subject to your lordship correction. I'm distinguished, my lord. How is it? Suppose my lord, the police officers, my lord, high-ranking police officer, he is the appointing authority. So government has a sanction and amount for rupees 20 lakhs for conduct and appointment of a constables. He is the, my lord, authority who conducted this entire appointment of the constable, and the government has sanctioned an amount of rupees 20 lakh for to conduct the entire. Now, what he had doing, my lord? Okay, advertisement was published, recruitment has been conducted. So out of
confine this 71 to a situation where there is a decision-making process is involved.
yes, now
Isn't it?
yes, sir.
Your case is that 17A protection is given in a situation, not as a general corruption or something like that.
Yes.
It is only for the purpose that a genuine
Yes.
decision taken, an officer has taken a genuine decision and he is not being harassed. So
But-
therefore, the legislature has used these two words.
Yes,
This is your argument.
Yes.
Therefore, you rely on the Madras High
My,
Court
yes.
judgment.
Now here, my lord, I'm completely said examples, my lord. Now what happened? He conduct the recruitment. So during conducting his equipment, out of 20 lakhs, he has used only 10 lakhs. Other 10 lakhs he siphoned. Now, when during equipment also what happened? He did, my lord, taking some bribe from the candidates and he gave the appointment. So this is corruptions. Then 17A will be necessary because he is the signatory authority of checks and all funds, my lord. This is the corruptions and then 17A is required. Suppose that same particular officer, after his office, when he was in home, he knows that there is some businessmen who have doing some illegalities all in like say Koila mafias and
Cow-
Supari mafias.
Cow mafia.
No,
Cattle
cow
mafia.
mafia. He knows everything, my lord. So what he said, if you not pay monthly 10 lakhs each, otherwise I am giving you trouble and I lose in FIR and put behind your back. Then every month he take a collections from this it's okay. Then how it comes under the, my lord, the official's duty, my lord. See, here the act says, my lord, that discharge of his official function or duties and misusing of official positions to different things, myself. First part is discharge of his official functions and duties. Admissions, my lord, the recruitments, signature of the funds and all. These are comes under the official functions. And the other examples, my lord, what I have given, my lord, whether it comes under the, my lord, the official functions and duty, my lord.
Not even official functions. Your argument is that it's relatable to any recommendation
Yes.
made or decision taken.
Yes, recommendation, suppose, my lord, there are 5 companies. One company's approach, recommendation is given, he gave the, my lord, tender to all these companies and taking bribe from this company. This is also, my lord, the comes under the 17A. Recommendation official duty. But this type of property, when he accumulated, how it can be comes under, my lord, the 17A. These are the distinguished from our side, my lord. So these aspects also we think about it, my lord.
Yes, ma'am.
Now, thereafter, you will also make kindly peruse the charge sheet.
Now, who will decide it is relatable?
Yes, that's
and
what I'm saying. They say that, my lord, in his, my lord, when at page, at page 178, you'll also may see. 178, the honorable court order, where it says, since the alleged accumulations of disproportionate assets is relatable to any recommendation made or decisions taken by the accused in discharge of his official duty, so prior approval for intention of the inquiry or investigation against him ought to have been taken from the central government. They have admitted. So who will decide, my lord? The learned trial court. They have to prove.
No. What I'm asking, trying to decide
Huh.
that it is because it mandates an inquiry, sanction is required. No police officer will conduct an inquiry in these two conditions. I'm coming to your argument only. That when the allegation is so far relating to making recommendation or decision taken by the public relatable to this, corruption relatable to this.
Yes.
Therefore, then it will be required. Now, who will decide that it is relatable or not relatable? To seek permission, because there must be a decision.
Ma'am.
If we go by disqualification, according to Mr. Chaudhary, in every case it is
Yes.
required.
In any case.
In any case,
Mm.
your argument is that it is required only when it is that it is relatable to any recommendation made
Yes.
and or decision taken. So there must be a decision or a recommendation, existence of decision and recommendation so as to do it. Now, who will decide that this is relatable? Inquiry officer will have to first decide, then seek, or he will have to, moment he gets a allegation, he will have, because FIR is not a gospel truth. Somebody may say he has made money, that may be on giving a recommendation or taking a decision that I will file a final report, not give a charge sheet, give me money. So that is he has decision taken, or charge sheet is a kind of a recommendation. If we confine to that, who will decide that? For that also an inquiry is required. Yes, just these are the
My lord, yes, these are the queries, my lord. And now thereafter, after registering the FIR, my lord, the charge sheet has been submitted at page 48, you will say, the charge sheet.
Yes, 48.
48. And page, your lordship, the relevant pages, page 70, your lordship.
We are basically whether when it is a PC Act, allegation under PC Act, in all cases, initiate an inquiry is, first it will come later on because you have investigated.
Yes.
Suppose you hold that this is bad,
Bad.
then
Then
everything
goes my-
gone. So let us not go to this.
My lord, yes.
Suppose
Just
you hold,
simply, my lord, why I'm-
hold that it is good, no, they can. We are not going to look into
Yes,
the
my lord,
specific.
here the purely question of law, my lord.
Yes.
Why I'm showing
But
the
not on-
offense, the
yes.
offense will attract, my lord, whether it comes under the 17A requires or not. That's why I'm showing, my lord. The charge sheet FIR,
Okay, okay.
yes.
okay.
That, my lord, just only I'm
No,
not
no,
wasting your
charge sheet
lordship.
FIR comes later on.
My
To
lord,
take
why
a
I'm,
decision whether I'll take a permission from the Honorable Chief Justice or not is different and subsequent facts are different. That will depend upon the first initiation. If we go by your argument that recommendation made and decision taken, how it is to be decided?
that's why, my lord, showing, my lord, the FIR is the main,
Its role will come later on
my lord.
at the subsequent level. At this stage, there is no role of the court except it between the investigating officer and the employer, isn't it?
My lord.
Okay.
Why am FIR, my lord, I'm showing before lordship, because it's reflect from the FIR whether it is a case of the disproportionate access or not. Whether the 17A applicable in this case or not. That's why I'm saying.
That is important.
Yes.
That is important. Yes.
Because my lord, things is start from the
Facts
FIR.
facts will always be
Yes.
relevant,
My
but
lord.
facts so far disclosed in the FIR or the complaint to
My-
start the
My
investigation.
lord. All lacunas has come from the my lord from FIR only, my lord. The entire, my lord, the technicals fault and also all things are comes from the FIR, my lord.
Oh.
When it was registered, what section they have registered, whether it comes under or not, my lord. And now, your lordship, the core questions of the petitions, my lord. Whether the accumulations, this is the, my lord, a simple note I have prepared for your lordship assistance,
yes.
your lordship.
Yes.
Yes, my lord, this is the, my lord, preparing a brief fact of the case. I'm not
Okay.
reading all these things, my lord, because the lordship already, my learned senior has, my lord, vividly described before
judgments is
lordship.
given.
And now your lordship come to a page 11, your lord,
Is 11.
page 11. Page 11, my lord, the serial number 8, where we have been written, my lord. Core question of the petition is that the core question of the instant petition, whether the accumulations of disproportionate asset is relatable to any recommendation made or decisions. The 17A, we are not read the same thing, my lord,
Yes,
already.
not necessary. Yes.
And now we come to the, my lord, the page 10. Page 10, you will see. নহয় স্যার এইটো আপোনাৰ হেৰি আপোনাৰ অৱধ কিশোৰ গুপ্তা কেছ য'ত আপোনাৰ ডিছপ্ৰপৰ্চনেট এছেটটো ডিষ্টিংগুইছ কৰে পেজ নম্বৰ 12 your lordship here para 10 the Prevention of Corruption Act 2018 amended the definitions of known source of income as contained in explanations by doing away the requirement of intimations in accordance with law, rules, or orders applicable to a public servant. Now, it means the income received from any lawful sources, madam. This is the judgment we have given, madam. The paragraph 567, your lordship. What is your lordship? The judgment?
Yes.
Para 5. By the way, to delay. Para 5 is 5, 6, 70, my lord, the relevant para of this case. Section 13 deal with various situations when a public servant can be said to have committed a criminal misconduct. Clause E of subsections 1 of the section is pressed into service against the accused. The same is applicable when a public servant or any persons on his behalf is in a position or has at any time during the period of his office been in a position for which the public servant cannot satisfactorily account of a pecuniary resource or a property disproportionate to his known source of income. Clause E of the subsection 1 of section 13 corresponds to clause E of the subsection 1 of the section 5 of the PC Act, but there have been drastic amendments under the new clauses. The earlier concept of known source of income has undergone a radical changes. As per the explanations appended, the prosecution is relieved of the burden of investigation into source of income of an accused to a large extent, as it is stated in the explanations that known source of income means income received from any lawful sources, the receipt of which has been intimated in accordance with the provision of any law, rules, order for the timing applicable to a public servant. The expressions known source of income has reference to source known to the prosecutions after thorough investigations of the case. It is not and cannot be contended that known source of income means source known to the accused. The prosecution cannot, in the very nature of things, be expected to know the affairs of an accused person. Those will be the matter of, especially within the knowledge of the accused, within the meaning of the section 106 of the Indian Evidence Act. 6. The phrase known source of income in section 13(1)(e), old section 5(1)(e) has clearly the emphasis on the words income. It would be preliminary to observe that for the public servant, the income would be what is the attached to his office or post. Commonly known as a remuneration of or salary, the terms income means itself is elastic and has a wide connotations. Whether comes in or is received is income, but however wide the important and connotations of the term income, it is incapable of being understood as the meaning received having no nexus to one's labor or expertise or property or investment, and having further a source which may or may not yield a regular revenue. These essential characteristics are vital in understanding the term of income. Therefore, it can be said that though income is a receipt in the hand of its recipient, every receipt would not partake the character of income. For the public servant, whatever return he gets from his service will be the primary item of his income. Others' income, which conceivably are income qua the public servant, will be in a regular receipt from or A, his property, or B, his investment. A receipt from the windfall or gain of graft, crime or immoral secretions by a person's prima facie would not be received from the known source of income of the public servant. And 7, the legislature has advisedly used the expression satisfactorily account. The emphasis must be one on the word satisfactorily, and the legislature has thus deliberately cast a burden on the accused not only to offer a plausible explanation as how he come by his large wealth, but also to satisfy the court that his explanation was worthy of acceptance. These are the, my lord, in these judgments describe about this disproportionate said that its known source of income was very clearly, my lord, elaborately discussed in this matter, my lord. And the honorable, we have relied, my lord, we are not reading the same thing, my lord, the Dhandapani case, the Madras High Court and Karnataka. We will mainly rely on the Karnataka, which was, my lord, explained very vividly. But my
Karnataka, which one? Karnataka?
Kerala. But my learned senior counsel has argued that 197, yes, that is the distinguished. So, Lordship, I am not repeating the same, but we relied still, my lord, the Karnataka and Dhandapani case. Thereafter, my lord, in our High Court, my lord, the judgment, the Indrajit Bora case, this is passed on, my lord, 18 March of 2024. Yes. The compilation
That
is
is that.
the same,
I'll just
in compilation is also there. no?
Yes, yes.
Because I don't need the page number, my lord. that's
Page
why.
178.
Here,
That was a case of trap.
my lord, no, my lord, I'm sorry, my lord. Here, this is a case of, initially it was a trap case. Kindly see, lordship, at page, paragraph 3. My lord, yes. On 15/9/23, Sri so-and-so, DSP so-and-so, laws and FR OC, effect that during ACB case number so-and-so, prevention trap was laid. Initially, it was trap. A lordship may come to a page, paragraph 4, my lord. Upon the said FR, officer in charge police station has registered a case being such and such case number, my lord. Under section so-and-so PC Act and endorse it. And later on, my lord, when during search it's found that then another case was registered, my lord, it's a disproportionate case, my lord. So here also, my lord, at page, paragraph 14, your lordship.
Paragraph
14.
1.
My lord, same issue was raised before this court. Same, my lord, subject matter has been argued. Where is also said that the 17A is applicable in this case. We argued that no, 17A is not applicable. Thereafter, this honorable High Court, my lord, has passed this order. Paragraph 14, your lordship may see. This being a factual position can be said that the accumulation of the assets disproportionate to known source of income of the petitioner relatable to any recommendation made or decision taken by him in discharge of his official function or duties. The answer is emphatic no. By no stretch of imaginations, it can be said that accumulation of assets disproportionate to know the source of income of the petitioner relatable to any recommendations made or decisions taken by him in discharge of his official function or duty. Mr. Fukan, the learned public prosecutor, has rightly pointed this out during hearing, and the ratio laid down in the decisions referred is almost strengthened his submission. These are the submissions, my lord, the decisions which we have relied upon. And later on, my lord, at paragraph 20, your lordship may see. The decision which have relied upon, this was discussed in the said order, my lord. Para 20, this being a position of this court the court is of the considered opinion that the section 17A PC Act is not applicable here in the case of accumulation of assets disproportionate to know the source of income cannot be said to be a discharge of his official duty. Therefore, the court is unable to record concurrence to the submissions made by the learned counsel of the petitioner. Issue number 1 is answered accordingly. And later on, my lord, the paragraph 22, where Nara Chandrababu Naidu was also discussed. My lord, there is no comments was offered by this honorable court because it was already pending before the larger bench. What Nara Chandrababu Naidu case, my lord, there both the judges' view was also recorded, my lord. The Aniruddha Bose, what he says in Nara Chandrababu Naidu case, and the what B. Trivedi, my lord, Bela B. M. Trivedi discussed, that was also recorded. And later on, my lord, however, in view of the decisions of issue number 1 and view of the given fact and circumstance record, court is the view that the present petition devoid on merit, according to the same stand dismissed, the parties have to bear their own cost. Here also, my lord, is a case of disproportionate assets case. And now, my submissions at page para 17, page 28.
Which one?
My lord, the note.
Okay.
In my note,
Yes.
in my written argument, my lord. Page 28, your lordship. Paragraph 17, your lordship. What it, your lordship? The object of the PC Act is yet to protect the honest and upright public officer and to ensure that they are unnecessarily not damaged into the litigations. It is also intended to ensure that the officers are insulted and protected against unnecessary litigation. Such a protections enable to the officer to take prompt and bold decisions on files, and the administrative machinery will move forward. Otherwise, the officer who be reluctant to make any official recommendations or to take any decisions on file, apprehending false accusations of corruptions. In this context, it has to be noted that the scope of 17A is specifically confined to any recommendations made or decisions taken by the public servant which alone fall within the protections under 17A. Definitely the case of the offense like misappropriations of fund, fraud, falsifications of accounts, criminal breach of trust, conspiracy, etc. cannot be covered by the protections under section 17A. Definitely they do not involve any decisions or recommendations at all. Such acts cannot be considered as one done in discharge of his official functions and duties as the contemplated under such 17A. Hence, it cannot be any stress or imagination be held in the investigations into any of the offense as mentioned above. Also needs prior approval under section 17A. Such an interpretation alone cannot be consonance with the section as interpreted by various decisions. In other words, the scope of 17 is only to confine to investigation, inquiry or inquiry into any offense which relatable to any decisions taken by the recommendation made by the authority. This purposive interpretation seems to be a consonance with the scope of the section 17A. Now the literal meaning, the legislature intent to rule of the interpretations, my lord, that I have, my lord, quoted in paragraph 18, my lord.
Just a minute.
Here, Dr. Manjula case, my lord, where the legal legislature intends rule of interpretations, my lord. Paragraph 139. tells. The legislature intent, my lord, that was discussed in this case, my lord, para 139. The golden rules in determining whether.
Just a minute.
My lord.
139,
139 year also.
Page,
139 para, my lord.
what is the page, internal page of the?
Internal page, my lord, the
Okay.
the
page-
judgment, my lord.
Yes,
The
yes,
judgment which was I have
139, page 14.
my lord, yes. Here it's, my lord, the says the golden rules, my lord, in determining whether the judiciary has the crossed the Lakshman Rekha in the use of the interpreting of statute is really whether a judge has only to iron out the creates that he found in a statute in the light of its object, or whether he has altered the material of which the act is woven. In short, the difference is the well-known philosophical difference between is and ought. Thus, the judge put himself in a place of the legislature and asked himself whether the legislature intend a certain results or what he think should have been done and had been the legislature. If the latter is a statute by way of a supposed intentions of the legislator or would go beyond creative interpretations of the legislation to legislating itself. It is at this point that the judges crosses the Lakshman Rekha and becomes a legislature, stating that the law ought to be instead of what the law is made. This is discussed in, my lord, this case that is reported in 2017, my lord. Now, here, my lord, the one more questions was raised. And the, my lord, the Nara Chandra Babu Naidu case, lordship may very much well, my lord, threaten me, my lord, what they have discussed. In Narabandhu Chaitanya is not a judgment, my lord. It is the two opinions and two view of the two judges. And the Naidu cases, my lord, there is no way it has been, my lord, discussed or, my lord, that the if this is sent to the larger bench, the cases where the approval was not taken, where the wrongly approval was taken, that should be stayed by the other judges.
It should relate back to the in a situation pre-amendment.
My lord.
17A.
2018. My lord. And my lord, in para 7, page 17, para 12, your lordship, in my note, my lord, where I have clarified the facts, from the facts, it is apparent the above referred case related.
Paragraph?
Paragraph 12, my lord, page 17, in my note, my lord, where I have stated that from the fact it is apparent that the above referred case related to misappropriations of amount, but the case in hand is related to accumulation of disproportionate of amounts. And there is a clear distinguished difference between the misappropriations and disproportion, in as much as the above refer is not applicable in our instant case. And next para, my lord, we have Sankara Bhatt, the relevant para, we have, my lord,
Kerala.
Kerala.
Your
And
whole basic Kerala has made certain explanation that
my
is
lord, yes, we have, my
whole
lord,
case,
the
and he has given a
Yes,
reference that that logic
It's
so
not
far like
applicable.
akin to 197.
yes,
197 is already in that opinion.
my lord.
It has been verified.
Sir, আৰু এটা কৈ দিছে
Yeah.
বেছি নকওঁ sir. In Chandrababu Naidu case, my lord, in paragraph 24, my lord, in my copy, my lord, probably lordship paragraph is different. But I'm reading, my lord, just one line. The Aniruddha Bose, my lord, what he discussed. If an inquiry or inquiry investigation intended to respect of the public servant on the allegations of commission of the offense 1988 Acts of 17A, thereof become a operational, which is relatable to any recommendations
It
made
is
or
bold
decision,
and emphasis given.
my lord.
Is your argument?
Only just line, my lord,
Uh-huh.
at least prima facie in discharge of the official duty, previous approval of the authority postulated in subsection so and so shall be obtained. In absence of service, the action will be initiated against so and so. Here, my lord, the word is very important, my lord. At least the word prima facie was used in this case, my lord. That is Aniruddha Bose, my lord, what his view is taken. So my humble submission before your lordships, that this is purely a disproportionate case. From our, my lord, investigations, what they have found by the investigating officer, charge sheet was they have found.
According to you, 17A will not come in a case where the allegation is under section 13.
Right.
Because under section 13, it is relatable to a specific decision or recommendation. This is your argument?
My lord, yes.
So therefore, that 17A will be required according to you only when the offense relates to a specific decision or a
recommendation.
recommendation.
Yes. Only 13B, my lord. Second part, my lord. That's why, my lord, 17A is not applicable, my lord. The order which was passed by this honorable court, my lord, the stay has been given, which is difficult for us, my lord, to proceed the case. So, lordship, my humble submission, my lord, before your
Mr.
lordship.
Chaudhary,
Yes,
come to this judgment, coordinate bench.
Yes.
Indrajit Bora,
yes.
paragraph 14. Though it is a bribe or subsequently disproportionate allegation, a distinction is made in at paragraph 14. How you deal with this?
One second. Para 14, my lord. Yes. This being the factual position, can it be said that accumulation of assets disproportionate to the known source of income of the prisoner, relateable to any recommendation made or decision by him in the charge of his official function or duty? The answer is emphatic no. By no stretch of imagination can it be said that accumulation of assets disproportionate to the known of the petitioner, relatable to any recommendation made or decision in the charge of his official function. My lord, this is not the view of the court, my lord. This is any reiteration of the provision of the section. My lord, can we digress from the fact that here is a
Do
case,
you know, therefore,
it's
we will
all
go
sta-
to, it will go further.
Yes.
Do you say that this is not a ratio?
not a ratio. It can't be the ratio. My lord, lordship knows every decision is an authority for what it actually decides.
Said.
A line or a sentence is a decision, is not a ratio decidendi. Now kindly see, my lord, paragraph 3, it all started with a trap case. That's why we said, my lord, where the factual foundation is totally different. Now, my lord, let us come to one very important aspect in this case. If your lordships will kindly take the compilation.
So just why I'm saying is because we'll, whatever decision, since it is relevant, we'll have to give an,
Certainly, certainly. my lord.
because paragraph 12, 13 also you can read it. How that 12, paragraph 14,
My lord, if your lordships will, no, my lord, we have explained the position. If your lordship will kindly come to our compilation, my lord.
yes.
It is also a written argument. Please come to page 9.
Yes.
Recently on 18/3/24, a coordinate bench of this honorable court in Indrajit Bora passed a judgment on section 17A. However, the said case was a trap case and accused therein was arrested following a trap. So that case is squarely covered by the exception contained in proviso to section 17A. Also, though the coordinate bench also observed that section 17A would not be applicable in disproportionate asset cases, but the findings were confined to the facts of the case.
That is the explanation because we'll have to
Yes,
record, no? That
exactly, man.
explanation is
Yes.
there.
In that, kindly allow me to read further.
Yes.
In that case, it was held that disproportionate asset had no nexus with official duty of the accused. In the instant case, the prosecution is alleging that petitioner has accumulated disproportionate assets by abusing his official position. In other words, the accumulation of disproportionate flows from the decision taken in the petitioner's official capacity. Further, the coordinate bench relied on Dandapani and Sankarao Bhatt to hold section 17A was not applicable to disproportionate assets cases. The coordinate bench
So
relied.
relating to Dandapani and Kerala,
that
I
Kerala.
understand your case is the Jaswanta Singh is clear.
Yes.
So these are, and you referred that 197 is not
Yes.
akin.
Yes.
These are there.
Now, my lord will kindly permit me to place 2-3 things on facts. Please come to page 12 of the
Compilation.
compilation. My lord, we have summarized it. I'll refer to the criminal petition, para 35. Allegation labeled against the petitioners are as follows. Petitioner enriched him illegally and acquired assets disproportionate to his income by being a part of a cow syndicate while posted at Bongaigaon. These are all relatable to official duty. Now, my lord, this page 24 is the complaint that by person. My lord, his statement that 161 was recorded, but he is not made a witness in the case. The charge sheet does not reveal his name. Kindly mark that much, very important. Especially when such nature of complaint comes, that is why section 17A was.
What I have said.
Then my lord will kindly come to page 13. Earned enough money through posting and transfer of junior officials. Amassed assets while being in public servant. Cash amounts deposited in account while he was DIG Western Range. Abused his official position to obtain pecuniary advantage. Now I'll place that complaint, my lord. Please take the revision petition, page 70.
Page
70.
70.
Yes, 17.02 paragraph. Investigation revealed that Ronokali Hazarika IPS were posted at different districts, organizations. As such, he was in a position to supervise the important criminal cases, and also he had transfer and posting power of junior official under him, and he had enough scope to earn money by illegally. So this can be done only by using my official position.
Decision making
Decision
and
making.
recommendation.
Recommendation. Then my lord will kindly come to page 77. My lord, some judgment here and there is not law. Everything is on the facts of each case.
Yes, yes.
On top, my lord, page 77, para 9. All these documentary materials, circumstantial evidence provide prima facie evidence that Ronokali Hazarika, being a public servant, had committed the crime of amassing disproportionate asset to his known source of income other than legal remuneration, which is a criminal misconduct on the part of the public servant. So, my lord, direct language from section 13. Then please come to page 128. In fact, if a lordship would kindly come to page 127, last two sentence.
Page 127.
Yes, it will hit in. Part of the charge sheet, my lord. Kindly see. Cash deposit amounting, page 127,
paragraph.
part of the charge sheet, my lord. Last two sentence at page 127. Cash deposit amounting to 2-3 lakhs in one go by self were found in his family's members' bank account. Some of the amount amounting to more than 12 lakh in cash were deposited by himself. Accrued while he occupied a public office then as a DIG. So there, my lord, the pleadings has made our case more strong. Page 131. They have argued, that's why, my lord, the trial court has recorded all this. 17.17. Sorry, yes, 17.17B. And he abused his official position as public servant to obtain pecuniary advantage. So are these not suggestive of the fact that whatever I did was on the strength of some recommendation or decision taken? So, my lord, their complaint, their charge sheet, my lord, makes our case foolproof to get protection under section 17A. Now, my lord, most important is section 6A of the DSP Act was struck down by the Honorable Supreme Court. Thereafter, this provision came. Therefore, the legislative intent. My lord, purposive interpretation will not come to their rescue. Purposive interpretation will come to my rescue. Because all that I'll urge upon your lordships, please look at the background. Why this provision had to be inserted. The idea was, because here is an app, isn't very, I mean, here is a case which was triggered by that page 27 complaint. And who is nobody, who is not even a witness. Therefore, my lord, everything was set in place, or rather the criminal proceeding was set in motion by that complaint. And they will not even inquire into it. My lord, the law on the point, of course, I'll say, my lord, once the referral judgment is there, it will be absolutely whatever, I mean, the misgivings, whatever is not explicit, not explicit will become explicit. But as on date, my lord, Yashwant Sinha is a judgment which clearly throws enough light on the subject. Therefore, to carve out that either disproportionate asset or acquiring any pecuniary advantage cases will not require section 17A. It is too early in the day to, my lord, come to that conclusion. And our High Court judgment, with all respect, I'll submit, my lord, it all started with the trap case. Therefore, it's not applicable. It's a distinguishable on facts. So in my humble submission, my lord, lordship will interfere with the order framing charge, and lordship will refer the matter back to the trial court.
I'll simply, relying the para, this, our High Court, my lord, para 2 is a quashing of the FIR, ACB PS case number 6923. This is a case of disproportionate case. They come for, my lord, the case where the disproportionate case.
Your argument is that initially there is a search, but subsequently 6 lakhs and odd were recovered from his residence. Then
A new
we
case was-
verified, then this was a disproportionate, and then therefore court has said that this is related. So this is a ratio. Paragraph 14 is a
and
ratio.
paragraph 20 and
12 to
20,
14.
my lord. The
Yeah.
court opinion is at page 20, para 20. Paragraph 20, you know. The court says, my lord, the 17 is not applicable.
And my lord, eventually the honorable, the coordinate bench of this honorable court relied upon, my lord, Dandapani and Sankara.
Much obliged.
Try to complete by in the mean, not possible also, because I'm in the division bench also.
Lordship.
13 we are fixing for further hearing.
My lord. Much obliged. Your Lordship.